Hello, everybody, and welcome again to me having a chat with somebody who is far more knowledgeable than myself. And today I'd like to welcome Philip Marcus, who is a retired Israeli judge. And his knowledge and wisdom of family law and family court is extraordinary. And the history of the Israeli culture to do with families is incredibly interesting. So, Philip, I'm not going to introduce you any more than that because you can do it much better than I can. So would you like to introduce yourself?
Of course. Thank you for the compliments. I hope they're justified. Philip Marcus, born in Birmingham in 1950, went to King Edward's School, got my law degree at University College London, qualified as a solicitor in Stoke Newington in North London, and I moved to Israel with my wife and 3 little children in 1978. I requalified as an advocate at the Israeli bar, and I had a private practice which gradually involved more and more family law cases. And in 1995, when the Israeli legislature passed the Family Courts Act, they were looking for judges who had experience and knowledge in family law. One of the provisions of that law is that in order to serve as a judge in family court, you had to have established knowledge and experience in the field. And that year, I had already put in an application to be selected as a judge, and I was selected so that I was one of the first specialist family court judges to be appointed in Israel. I sat as a judge until 2012, when I took early retirement. In the course of serving as a judge, I did a master's degree at Haifa University and realized that I enjoyed academic research and writing, and that rather than asking for promotion to a higher court, I'd rather retire and get involved in research and writing and reading and thinking about the things I wanted to deal with. Obviously, as a judge, you do a lot of reading and writing, but you're restricted to the specific cases that come before you. And I thought that I had more to add. So that's what I've been doing for the last 9 years, and expanded from family law involving children to family law involving the elderly and people who need guardians for various reasons. And in recent years, I've been doing quite a lot of comparative work, comparing family law and family courts in different countries. And I have come to the conclusion that Israel and recently Singapore have reformed their family court system. It's quite similar to ours. Come to the conclusion that the Israeli system is one of the best in the world. It may be that in the course of this talk we will explain how that came about and why. But the fact is that Israel is a common law country in the sense that the British were here from 1917, when Allenby beat the Turks, until 1948, when Israel declared independence. They set up a legal system and a court system which was based clearly on the common law idea. And it's also a fairly small country. We now have 9 or 10 million people, which gives it a certain amount of flexibility and agility, and a willingness to try out new ideas, which may not be the case in a larger jurisdiction with a longer history. So in the time that I was a judge and since, there have been a number of very interesting innovations which have been introduced into the system, firstly by piloting in different courts, and then extending them to the general system, including special procedures for hearing the voice of a child who may be the subject of proceedings, and also an increasing emphasis on alternative dispute resolution and diverting couples, particularly when they have children, away from the classical common law adversarial process onto educating them about what might happen to their children if they don't reach an agreed result, and so on. So we can touch on each of these things in turn. You mentioned that Israel has a particular approach to children, and in my reading and meeting people from other countries, it appears that might not be so much emphasized. For example, based on ancient Jewish law, a father and a mother are jointly the guardians of their children, have all the responsibilities for the children, regardless of whether they were married, unmarried, divorced, or whatever. That is not the case in many countries, where an unmarried father has to establish his parental rights or responsibilities. We may talk about the difference between rights and responsibilities. But already in 1951, Israel was just over 2 years old. The Knesset, that's our parliament, passed a law saying, among other things, it was a law actually for the equality of the rights of women. First law in the world expressing equality for women in the family. And that said specifically that the biological parents are automatically the joint guardians of the children and have all the responsibilities for the children. That was repeated in a law of 1962 and expanded. And as I say, it's not the case in some countries, many countries, that a biological father who's not married to the mother is automatically vested with responsibilities. I know that in England, it's not yet the case that the unmarried father is automatically vested. In addition, grandparents, and I know that's a specific interest of your group, Jane, grandparents have status. The 1973 Yom Kippur War took a huge toll of men who were fathers. And it was found that the parents of those deceased fathers, the bereaved parents, were having some difficulty being in contact with their grandchildren for all kinds of reasons to do with the widow and other reasons. So the law was amended in a little after the Yom Kippur War to give bereaved grandparents standing to approach the court for arrangements so that they could be in contact with their grandchildren. That was extended more recently so that even grandparents who are not bereaved can approach the court for contact, but they do not file a full claim with a statement of claim. They apply to the court for dispute resolution. Right. And that case is referred to the Family Court Social Services. The Family Court Social Services were introduced in the 1995 legislation. These are experienced social workers who are attached to each court, and the process of dispute resolution involves filing a short document simply with the names of the parties, the names of the children and the ages, and that there is a dispute that needs to be resolved. And the social workers will then, in the case of grandparents, call in the grandparents, they'll call in the parents, they may see the kids, and they will make recommendations. If an agreement is reached, then that agreement is brought to the judge for approval. If no agreement is reached, then it having been through the Family Court Social Services, the grandparents can then make a claim, and that will be dealt with in the ordinary way by a judge.
Oh, I see.
So that gives you some idea of the orientation of Israeli law and the Israeli courts relating to parents and their children, and also relating to grandparents and grandchildren. And that is something which I think is probably quite unusual for other countries.
Yes, yes. In your experience within court and the procedures of unjustified estrangement, using a slightly different phrase there, as you know, that's what I'm trying to do. And did you have many experiences of grandparents coming before you personally?
Yes, I had quite a few cases. We had, as you may know, at the beginning of the 1990s, a large immigration from the former Soviet Union. Jews under communism were not allowed to leave the Soviet Union. As a result of perestroika and glasnost, about 1 million people came from the former Soviet Union. And in many cases, because that was recommended, there was only one child, which would mean that for any couple, there were two pairs of grandparents who only had one grandchild. Yeah. Therefore, there was a great need of these grandparents to continue to have contact with the grandchild. And when that wasn't happening, so they would come to the court and they would explain what was going on. So we had several cases of that kind where for whatever reason, the grandparents were not seeing the grandchild. So that's one sort of sociological reason why that happened. There are also, of course, fallings out between a couple and the parents of one of them, and those may lead to an estrangement in the broadest sense. They just aren't talking to each other. Yeah. And as a result, the grandchildren don't have contact with the grandparents. On the other hand, there are cases in which one parent alienates the child from the other parent, and the parents of the alienating parent are with the alienating parent and gang up on the alienated parent. But there are cases in the other direction as well. So you get all kinds of permutations of involvement of grandparents. Mm. I can tell you about one case that stands out. I've written it up. This was a case in which 3 or 4 children, and the mother died of cancer. Yeah. And the father was looking after the children, and he applied to the court to ban the grandparents, the parents of the mother, from seeing the children, because he said when they met the children, they would blame him for being responsible for their daughter's illness and death. And they would say rude things about him, and he wanted them to stop. Now, let me just take you through what would have happened in that kind of case if we had not the family court social services. The grandparents would then file a statement of defense saying one of two things: either we never did it, or we did it and it's true. The father would then say, okay, I want a trial. And in the course of that trial, the children might have been brought in to give evidence. But in any case, the judgment of the court would have declared either the father or the grandparents to be lying. Yeah. The grandparents for denying when it was found that they did say such things, or the father for saying they did when in fact they didn't. Mm. And the result is that the children would lose the grandparents or might even lose the father because of that. Instead of that, the case came before me and I immediately referred it to our court social services. And they selected one of the social workers to deal with the father, another social worker to deal with the grandparents, and a third social worker to talk to the kids. Yeah. And the following things came out: that the deceased mother was the only child of the grandparents. The grandparents had both survived the concentration camps in the Holocaust. The father had always had somewhat rocky relationship with his parents-in-law. And the children loved their grandparents and loved their father, didn't want to lose either of them. But there had been some things said. And when the father had told the grandparents not to have contact, they would wait outside the school gates and talk to them then. and that got the father even more upset.
Yeah.
So after a matter of very few weeks, the social services unit came in with an agreement between the grandparents and the father that the grandparents in the first stage would have telephone conversations with the grandchildren, supervised by another family member who was acceptable to both sides, who would be able to stop the call if any improper content was conveyed, and that gradually they would build up to a situation where the grandparents and the grandchildren would have a good relationship. So that's an example of how the judge has the power to make vigorous orders. Yes. In the case. The social workers have the court behind them, which is an incentive for all the parties to cooperate with the social workers, which may be not possible if the father had applied to the social work department or the grandparents had applied. So that you have the therapeutic input and the treatment approach backed by the power of the court. And at the same time, the court is supported by experienced social workers who know about family dynamics. They know about child development. They know about the importance of grandparents. And a satisfactory result was achieved. So that's just an example of how a case involving grandparents can be handled in a non-adversarial way, but within the court, providing the framework for the therapeutic work.
Yeah, so it's support for all, isn't it, really?
Yes, absolutely. Yeah. And that's very much the ideology of the Israeli family court. But it depends on the judges receiving training and having experience. We have a Judicial Studies Institute, which offers training in all kinds of topics for the judges. But family court judges are required to attend one family court seminar that can be 3 or 4 days. It used to be residential, now of course it's done online every year. And every year they'll select a different topic. So every 3 or 4 years there will be a specific seminar about children, parents. It may be about child support and maintenance, or it may be about contact. It may be about that they're planning one on parental alienation for next year, and that'll be addressed not only by experienced judges but also by members of the appropriate professions, psychologists and psychiatrists, social workers, and others who can address the issue.
Yeah.
Those seminars are compulsory.
Yeah.
In other words, a judge who does not attend these seminars will get a wigging.
Okay.
That might be an inappropriate word because we don't sit with wigs in Israel. My late beloved father was very upset when I chose the solicitor's profession because he'd been brought up on Boyd QC and other things and very much liked the idea of the wig. However, the judges do wear a black gown.
Okay, well,
they have to wear a white shirt and a black tie. So he got that at least.
That's smart.
But anyway, a judge who misses these seminars, the president of his court will want to know why, and will encourage him to attend.
Encourage is a good word. We sort of moving on a little bit from that. I don't know obviously about Israel, but certainly in this country and others that I'm aware of, we continually hear of child arrangement orders being breached and there being no consequence. Now, I believe there are consequences, but it seems in many cases judges choose not to use those consequences. And rumor has it that you had a reoccurring mum, I believe it was, who kept coming back because she had breached an order. And you suggested that it might be an idea if she bought a toothbrush the next time, because you would actually send her to prison. And I believe you didn't see her again. I mean, is that just rumor?
No, it is, in fact, a resolution which I like to reminisce about. This is a young couple. She had previously been married and divorced. And the case came to me because one of the principles on which the family courts in Israel are based is one family, one judge.
Yeah.
So this case had started with her and her ex-husband. They had one child, and there were certain issues about visitation. I dealt with them. A couple of years later, she remarried to a young guy. It was his first marriage, and they had a small child, a baby, and they fell out. And he applied to the court for contact, saying that the mother was refusing contact and was giving all kinds of excuses. And then, being inexperienced in contact refusal and contact interference, I used the usual process. I sent them to the support unit, and the lady, who was very verbal, highly intelligent, was able to, say, yeah, fine, and do the opposite. I then contacted a contact center in order there should be supervision that she did, in fact, bring the kid on time, not because the father had behaved in such a way as to need the child needing protection from him, but simply as somebody who will referee the comings and goings. And she didn't show up, and then she explained, and she said the kid was ill, and when she was asked to bring a medical note, didn't do so, and then she fomented arguments with the social workers, and so on. In the course of this, she changed her lawyer 3 times, and I was able to pick up from when she was unrepresented. She would file her own documents in what was a pretty good copy of legalese, but explaining her entire life history in each document, that this was a person with a personality disorder, probably borderline, in view of the way in which she had ended her relationship with the first husband. And I realized that mediation would be hopeless because she would be able to manipulate it. Extremely attractive woman, as I say, with the gift of the gab. And in the end, I said to her, look, these are the arrangements. And if little Johnny, is going to be with Dad on Saturday and Sunday, and if he isn't, then you show up in my courtroom at 8:30 on Monday morning with a toothbrush. I got that idea actually from a judge in Nova Scotia whom I'd met at a conference, and he said, do this. And I said, I'm going to send you to prison for 3 days. And in those 3 days, little Johnny's going to be with Daddy anyway. So which do you prefer? And she stopped her nonsense.
Yeah.
But this goes to something which, again, I have come up against in many, many jurisdictions. The judges make a very good attempt to resolve the issue. They then have a fact-finding hearing, and they hear the submissions of the lawyers, and they write a learned judgment, and it's taken months or years to reach to this. And they make an order that this is going to happen, and then nothing happens. This is bad for the child, obviously, because the court, having heard evidence, including expert witnesses, has come to the conclusion that the child does need contact with the parent with whom he is having no contact. But it's also bad for the system, because it makes the judges and the courts a laughing stock, because they invest huge amounts of time and, of course, public money in writing, getting to judgment and writing the judgment. But then there's no enforcement. So the state has an interest in making sure that these orders are in fact enforced. And judges and lawyers need to know what to ask for, because if a judge is not asked to impose sanctions, then the judge may, according to some jurisdictions, not be authorized to do anything beyond the scope of the application before him. In Israel, it's not that case. In Israel, there is a section of the capacity and guardianship law which gives the court very wide powers to do what's necessary in the interests of a child or a disabled person on the application of one of the parties, or an application of the Attorney General, or suo sponte, in other words, of its own volition, in order to ensure the welfare of the child. So that the courts here have developed a whole range of sanctions short of imprisonment or fines for a recalcitrant parent who is not allowing contact with the other parent. That can include banning a person from leaving the country. It can include suspension of a driving license. It can include preventing the person from getting credit cards or opening bank accounts. It can include imposing a fine on a rising scale, or paying costs to the other party. So with the first breach, it'll be 300 shekels, which is £100 or thereabouts, and the second will be 600, and the next time it'll be 1,200. And in some cases, these are effective. But what is essential to all this? I mean, there are a number of essential parts to this, because if the order given by the court is not sufficiently detailed, then the recalcitrant parent and or the lawyer can say, well, this wasn't a breach because. So that means that judges have to be helped by the lawyers, and also have to learn how to draw up an order which is, as far as possible, watertight and bomb-proof, with giving times and dates and places where things are supposed to happen, so that it's a simple matter to prove that what was supposed to happen didn't. It also depends, as I say, on lawyers knowing what to ask for and judges knowing about their powers. It also depends to some extent on the judge knowing who the parties are. The advantage of one family, one judge is that the judge will deal with the case involving these parties and all other cases involving those parties. So he will get to know the personalities involved. That is a huge advantage over a system in which a case involving a particular child can be bounced from one bench to another, or from one judge to another. The one family, one judge system, which is being adopted slowly in some jurisdictions, but as far as I know, it doesn't yet exist to any great extent in England. They have the idea of judicial continuity that was introduced in the law in England fairly recently. And at least the family courts sit at family court centres and so on, but they haven't got the idea. That may be for structural reasons. That is that many cases are dealt with by recorders who are appointed per case or for a fixed amount of time. And when you're dealing with benches of magistrates, they can't be expected to be hauled in every time the case of Mr. and Mrs. Bloggs comes up. But it also depends on educating the listing offices and giving the judges more control over their diaries. But as I say, one family, one judge is a very useful contribution. Because you get to know who the bodies are.
Exactly. So, I mean, having said all that, is family court the place for family breakdown problems?
Absolutely not. I'm working with a number of groups in Israel and around the world. We have a group called In Between in Israel, and I'm a member of their consultative board, and I'm working on various projects which are aimed at educating the public about family relationships and responsibilities to children, so that in the case of a couple considering breaking up, they will do so in a way which least damages the children. We are now, we have later this week a meeting which we hope will finalize a document which will be aimed at couples who are considering separation and divorce as to what to do in order to, mitigate as far as possible the effect that it has on children. And that involves, first of all, making them understand that whatever hell they're going through, and however badly their expectations have been exploded, the other party is also probably thinking like that. And the children are picking up the dissatisfaction, even if they're not present, because children are very perceptive. And therefore, from the very outset, they have to put the children's interests first. And that means that they should be getting help from relatives, from religious ministers, from professional guidance as to how to do the separation and divorce. We've given a section on how to tell the kids what's happening, because that's extremely important. And as I say, that's one of the things that we're doing in order that these cases should not get to court. Jane and I are working with an organization called Two Wishes. This is an organization which was set up by David Curl in Australia and Nick Child from Edinburgh, and I was also involved in setting it up. And that's aimed at changing the way in which people regard families and having children, and so that it doesn't become a knee-jerk reaction. Well, I'm fed up with him or I'm fed up with her, and go and see a lawyer who will then encourage the party, if the lawyer is either unscrupulous or not sufficiently educated, to pour out all the bile and all the wrath and all the evil things that were done from when they had their first date, and send a rude letter to the other parent, which of course encourages the other parent to go and see another lawyer who will pour out all kinds of stuff. And all that makes any hope of conflict resolution extremely remote, and basically encourages inserting the family into the court system. That needs to be stopped. And we realize in Two Wishes it's going to take a generation. But it really is a matter of changing the way people look at family relationships and look at parenting, so that when it breaks up, you have to look after the kids. And in Two Wishes, again, we are working towards this. One of the central things that I'm talking about is training of professionals as well, because a poorly trained social worker who has been educated to sympathize with whoever's sitting in front of him or her, or a psychologist, will inevitably almost not see the signs of inappropriate behavior by that client vis-a-vis the other parent of the children. And will tend to swallow whole whatever's being said. And that's why I've written an article about how social workers should be involved and how they should act in a case where a couple are splitting up and there are children. I've just finished an article now, which I hope will be published, about how lawyers ought to behave in a case where a client presents and says, look, I'm splitting up from my partner and there are kids, and a lawyer should be aware of the damage that can be done if it's not done properly, and should also be aware of whom to refer the parents to in order to deal with things properly. I've given lectures to school counselors and to teachers about how they, as the people who are most in touch with a child, should be able to pick up the signs of a child who is distressed because the parents are fighting or breaking up, and call in the parents and advise them to get help, so that if they are going to break up, they can do so in a way which is going to cause as little as possible damage to the child, and also to get help for the child.
Yes.
So
I think
so I'm saying it's a multidisciplinary thing.
It is.
It's a matter of training.
Yeah.
I've recently finished a course for senior officials of the government in Malta, teaching them about parents and children, parental alienation, how to prevent it, and what to do when it happens.
Yeah.
And they'll be receiving their certificates in a few weeks' time. And I'm consulted by people from a large number of different countries as to how to do reform.
This is about education, isn't it, to everybody?
It's education for everybody.
Yeah.
Education, even going back, I know you have a history in education, even going back to youngsters in high school who are learning about relationships, and they should be learning not only about relationships in the formal and physical sense, but also about the responsibilities that they have to each other and to any children that may, that they may have.
Yeah.
In our generation, in the last century, everyone's been banging on about rights, and I wrote my thesis for my master's degree about why rights are the wrong way of looking at relationships and the wrong way of looking at law. Upsetting, I have to say. Many of my colleagues, particularly in the United States, and of course, we have the Universal Declaration of Human Rights of the United Nations in 1948. We have the European Treaty on Human Rights and Liberties, and I have researched this and come to the conclusion that rights are selfish. Rights are what I'm entitled to, regardless of who I am or what my behavior is, and it's individualistic, it's egotistical, whereas responsibilities involve relationships, involve another person or persons, and therefore it's no longer a matter of I want and I need. You might put it in this way: it's not about me, it's about we, and that is part of the paradigm shift that we're working towards in order to get rid of this selfish way of looking at things. It's true, obviously. Somebody who is in a relationship that's broken up is wounded,
of course,
and it's compared to the process of bereavement and mourning.
Yeah.
And the traditional way of looking at mourning is having 4 or 5 stages, one of which is disbelief, the next one is rage and anger, and it's the important job of anybody who meets these people, including family members, but also those in professional positions, to move people along to the next stage, which is, it may be sadness, but towards understanding the situation. There's nothing you can do to change what's happened, and you have to live with the things for the future. thereby
of acceptance.
preventing the depression from taking over.
Exactly.
And enabling hope and looking to the future. So again, this is all part of the training that I'm suggesting for students of social work, students of education, students of medicine, law students, of course, that it should be in their heads when they're faced with cases of this nature.
We're talking about a cultural change and a society change, aren't we, really?
Absolutely, absolutely. And you can throw into that, if you want, the replacement of religious belief with all kinds of strange ideologies, and the failure to understand that a child's identity is formed not only in his relationship with his parents, but also in his relationship with his culture and his forebears and his ancestry and his nation, and also how he identifies with his future, and his future also depends on looking forward as to what he expects from his life. There are some appalling statistics, mainly from the United States, but not only from there, about children who are growing up without fathers. In some communities, 50 or 60 or 70% of children are growing up with mothers, and the father simply is not interested, and at best is regarded, you'll pardon the expression, as a sperm donor and a cash point, but it takes no interest and thereby no responsibility. And these are children who are growing up with a distorted, truncated idea of who they are and where they come from. And the reasons for that are manifold. I'm not going to get into a discussion. Unfortunately, these discussions become highly charged politically because of all kinds of influences, and the societies are breaking down because of the loss of a parent and a grandparent, or the absence of a parent and a grandparent. And it has to be said that one of my colleagues in Israel, Yoas Sorek, has done a review of the literature and done some studies of what are the factors which mitigate the damage to children whose parents are divorcing, and finding the grandparents are a very, very strong mitigating factor, provided that they do not align themselves with one of the parents, because they provide the warmth, and they provide the unconditional love, and they provide the continuity, the view backwards as to where the child comes from, enabling the child a firm platform to jump off from and look into the future. The grandparents can be a very strong foundation for a child. It's been compared, when the parents break up, the home, which is the firm base from which a child jumps off, starts to crumble around the child. But the grandparents and the community can provide an alternative firm base, thereby mitigating some of the damage from the loss of the firm base in the family home.
And that seems to me a perfect place for us to stop, because there is a ray of hope in what you've just said at the end, and hope something we need to hang on to in all of this situation that so many find.
Again, as you say, it requires a paradigm shift. It requires a shift in the way we look at the concept of family. It requires going to an issue of responsibilities. I'm now doing the final edit of a book which will talk about responsibilities. At the moment, it'll be in 3 sections: responsibilities in family life. That'll be for a more general audience, and then responsibilities in family law and responsibilities in family courts. I'm trying to put forward this idea of responsibilities as a way to help kids and their parents.
Absolutely.
And their grandparents.
Absolutely. And responsibility for me is where this all comes from. Philip, I can't thank you enough for giving up your time so generously for me today. And if
we can help one child somewhere, even in Bristol,
I agree. Even
then you know we've saved the whole world.
Indeed.
Because that child is going to have children and grandchildren and great grandchildren, and you know you save a world.
Thank you so much, Philip. Thank you so much.
Thank you for inviting me.
It's been a pleasure. Thank you.